Hello, hello, and good afternoon, everyone. Good afternoon. Hope everybody's doing okay today. And let's get started. Hello and welcome. I am Tina Patterson, Principal Attorney at Patterson Justice Council in Detroit, Michigan, where pursuing justice is our business. We help people protect their property, have their rights respected, and leave legacies to their lineage. We do this because we believe the law should be used as a tool for construction to build up rather than destruction to destroy. We recently released a series titled What Will You Fight For? And in that series, we discuss key concepts that are critical to our experience of life and why it is necessary to fight to keep these items in our favor. Today, we're going to be discussing some practical tools that will help to increase the legal victory that is always possible to those who refuse to succumb to defeat before the battle begins. So, we're not going to be talking about the why, but we're going to start the how. Okay. Now, in any legal situation, there will be risk and there are no guarantees. People often want a sure thing. They want a guarantee before taking any action in a legal situation. But again, often that only prolongs the negative aspects of the case. So it can cause more stress because they're just waiting and building up this anxiety. They waste valuable time and energy because all the time that they feel stressed and anxious, nothing's actually happening to move the needle in their favor. And possibly worst of all, it costs more money because the sooner the situation is handled, the less is usually required to address it. Now, the more time that goes by and the more can build up in the case, the more work will might have to be done to get the favorable outcome. Whereas we could have had it done sooner from the beginning. So people often worry about the cost of the legal case up front, and then they let the time go by, and that time actually makes it cost more. It's kind of counterintuitive. People don't think much about it, but that's a consequence of just kind of sitting on it. So today, we're going to talk about things you can do right now, even before you spend any money, instead of being stuck in fear or uncertainty. I'm going to give you 3 tools that you can use to increase your chances for a positive outcome for legal victory. So those 3 keys: examine your products, express your position, and employ expert professionals. Now, the first 2, obviously, you can do right away. The third one really could be the second step, but I understand that some people are still kind of sketchy about this. So I want to tell you right up front what you can do, and then how number 3 is actually going to help you even more. So first, examine your products. What do you already have that can help move the needle in your favor in any legal action? Okay, whether it's a complaint against you, whether there's some kind of discrepancy, whether there's an argument, a conflict, whether it has to go to court or not. Maybe it's just a simple disagreement that you think might have some potential legal consequences, but you don't even need it to get that far. What do you have right now that can move the needle in your favor? Uh, so oftentimes, as soon as a complaint or other potential legal notice is received or even looks to be brewing up, people get into a state of panic. But don't panic and don't be intimidated, okay? But also, just as importantly, do not ignore anything that you have received already. If it looks like legal actions may be implied or may be forthcoming, or again, might just be starting up, you don't know, but it looks like it could be. Don't ignore that, because often there are times when people ignore notices, believing they're not legitimate, or they panic and they fail to act out of fear, or maybe they think, this might be something, but I'm going to let it go. Now, use your own intuition, but know that nothing will be changed until it is faced. Okay, and most importantly, when it comes to legal rights and options, don't allow any challenges to possibly forego those legal rights and options. Okay, do not allow your legal rights and options to challenge any possible action against you pass by because you were afraid, because you didn't know, because you felt intimidated, because you just kind of passively ignored it. That can add up to a much bigger consequence later. It's kind of like if it's snowing and it just starts off in little flakes and little flakes, but it's going to be snowing for 12 hours. And after 12 hours, it's not just little flakes on the ground, there are inches of snow. You have to dig out of it. Okay. Don't let those little things just continue to flow down. See that it's snowing and make that necessary precautions and preparations so you don't have to dig yourself out of it later. The same thing with a legal case, okay? So what are these things that I can use? What do I have? I can remember sitting with a client a few months ago for a consultation. Ultimately didn't retain, which is fine. But the consultation was very helpful and beneficial because the client needed to respond within a week or so. And I wasn't available for that, but I gave her some very constructive steps. What do you have in front of you? The things that you told me, make that into an argument. So, do you have the things that we're talking about here? Do you have a contract that has important factors to help your case? Do you have any other written agreements or policies? Do you have any statements or payment slips if it's like some kind of money issue? Whatever the situation is, do you have something, especially if it's written, if it can be objectively proven, right, outside of what you're saying? Do you have something like that that can help you? On the flip side, also, do you have something like that that can hurt you? You do need to be honest about what is available to you and what the situation is. So don't be afraid of what we call so-called bad evidence. Okay, things that might not look good, because this can also be used in a constructive way in a case. And that'll get to number 3 when you do seek expert advice, but don't try to hide that. That's only going to hurt you. We're talking about things that can help you. Okay, so what do you already have in front of you? What do you already know you can get? Who do you know? If you know anybody that was maybe around, start trying to think of just these pieces of evidence that can help you. Don't worry about whether it's going to be feasible or not yet. Just what do you know right away that you can help yourself with the situation? Okay. The most important part is to gather what you have to make the best case possible right away. Second is to express your position. Okay. Again, I would have this as the final step, but often timelines or funds may hinder the final step, which is seeking expert advice. So when in doubt, make it known, plain and clear, what your position is. When it comes to legal actions, it is important, it is imperative, it is paramount. Okay, it is number 1 priority. Express your position as clearly and definitively as best as possible. Okay, if it's already in court, respond to every document filed so that your position is on the court record. Include documents that you may have gathered from that first step we talked about to support your position. Okay, this is going to help you. Again, do things that's going to help you. By putting your position right there on the court record, you also save future legal options that you may not even know about down the line. All right, such as taking it to a higher court and challenging maybe something unfavorable that may be down the line. Always act in your own best interest and your own favor, even if you don't need to yet, but just set yourself up to do so. Never fail to respond. There are 2 major consequences with that. Now, first, because there will be no record of you ever making your position known in case you do want to overturn an unfavorable decision that might come down the line. In case you want to challenge it later, what can you challenge? There's nothing to challenge, right? That's number 1. But the second is also because it just doesn't help you. It doesn't make you look good because it makes it look like you don't care about the matter. So why should anybody else? Again, always act in your best favor, okay? Not against yourself. I read this in a book recently and it was mind blowing. It wasn't even a book about the law, okay? Few books I read are actually about the law. I have my own professional tools that I use to keep myself and my legal skills sharp, but the books I read are mostly not about the law. And this line was still in the book, and I thought it was just so appropriate to what it is I do and what we all can do. Never make the case against yourself. Never make the case against yourself. Now, that doesn't mean that you are doing something. It means maybe not doing something. Okay? So you might not be saying bad things about yourself, but you're not acting in your own best interest. That also does make the case against you. We don't think about it that way, but it's something to think about moving forward. So always try to act in positive momentum in your own favor. All right. Now, last is to employ expert professional help. And when it comes to a legal case, not just any lawyer will do. Seek legal counsel from a trained lawyer who is competent in the area that you are facing and one who will fight for your best interests to ensure that your needs are going to be met. An example of this is I'm often sought out for family law issues, which are things like divorce, child support, custody, etc. I don't do that. I make it known I don't do that. I don't want to do that. Could I? Yeah, but I don't want to. It's not my interest, and it's not what I feel like I'm called to do. So I will tell a person, I don't do this, but I can get you some help that will better serve you. I remember also speaking with a client some months back who had a feeling about an attorney for her family law case and was asking, I sought this first attorney and I liked her more, but this next one, I just didn't get that right feeling. Am I, there's something wrong with me? And I said, no, no, you need to go with who you're comfortable with, who, again, you think has the expertise in the area that you need, who you think is going to listen to you, who you think is going to act in your best interest, and who you think is going to get that result for you. It's very important. And kind of related to that, I have other attorney friends who they don't do probate cases, which means, someone passed away, we have to take care of this issue. And they'll reach out to me for support because they know that I know how to do that. And that's one of my core competencies in the areas of the law. And so I can advise on that, right? But they're not going to do it because they don't know. So while having legal counsel is a major advantage, again, having counsel that will competently and zealously represent you is more important to give yourself the best chances of resolving your case favorably. And once again, if you retain counsel and you feel that the advocacy is not up to your standards, or you just feel like, I'm not really being heard, my position is not really being expressed, my needs are not being met, you are within your right to seek other counsel to better suit your needs. Okay. Now, just because you're not getting the result you want doesn't mean that that attorney is not working on your behalf. Again, nothing is guaranteed, especially when it comes to taking it to court. There's two sides, right? So it's either going to go on this side or that side, but there is no 100% here or 100% there. But if you feel like the attorney is just not doing what they need to do for you, right? Even if you're not getting the result, that's one thing, okay? But if the attorney is working hard, if they're showing up to every court meeting, if they're calling you, if they're emailing you, texting you, they've built that rapport with you, then you can see that they are trying to put in the work. I realized this in practice some years ago that the best clients, they want just to see that you're working for them, that you are actually trying, right? So if you have an attorney like that, that's good. But if you don't see that, then yes, please go seek a second opinion if you need to. You're within your right to do that. So those were the 3 keys, again, when it comes to increasing your chances for legal victory. Examine your products, express your position, employ expert professional. And today I'm going to give you an extra tip. Okay. So number 4, don't panic, but also don't delay. All right. So often I get asked to represent someone who has a court hearing the next day or literally the next morning, not even a 24-hour notice. And sometimes it's even the next week, but I just don't know anything about the case. I don't know anything about the person. I would not be doing my due diligence as a professional by just taking on any case. And more importantly, I would not be serving any client to my best ability and to their best representation by agreeing to help them with no information. It would just be a disservice to them. And now I can, say, yeah, I'll do it for this X amount of money, and it's going to be an emergency fee and a premium fee on top of that. But that wouldn't do anything for me, and it really would do less for the client, and that's not what I'm about. So don't panic, but don't delay. Take the time to think about your best course of action, but don't sit into a panic and lose time to take advantage of these options. A lot of times you could be up against the deadline. If you know you have a court date coming up, don't wait until the night before. Don't wait until the morning before. Don't even wait until the week before, because you need that time for preparation. I know that, and I guess that's why I'm kind of conveying this. These are our little secrets. Lawyers, we know how to prepare for our cases, but we don't prepare for the first time the night before, right? Whereas someone who doesn't know what they're doing, they don't know where to start. So maybe it is the night before for them. But if I'm going to be helping you the way I need to help you to get the best out of the outcome for you, I need more than a night before. Sometimes I do need more than a week before also, right? And so the client might not be in that mindset. Person facing legal action or looking for legal help might not be in that mindset. So this is a tip. Don't panic, right? But don't delay, because the delay is only hurting you. It's really not hurting me. It's not hurting the court. It's really not hurting the other party if it's that kind of a case, right? It's going to hurt you. So again, always act in your best interest. The best clients who have been able to get the best results for have done these 3 steps, right? They've gotten all their documentation together. They've put their opinion out there on the record, or their position out there on the record. Even if they didn't have an attorney to start off with, they made it known what their position was, okay? And then lastly, yes, they did finally secure an attorney who was going to zealously advocate and represent their position, and one who was competent to do that. All right. And then they didn't panic. They started months ahead of time. If a case came up against them, they were on the deadlines. They were on the timelines. Okay. Because it's very important that you don't miss those. Yes, we're all human, but when it comes to the court of law, there's certain deadlines, timelines, and behaviors really too that you want to take on to act in your best interest. All right. And so I want to share a little bit of that insight with you today. I hope that information was helpful and actionable. Many people who don't know what to do often think that they don't know what to do because they don't know the law or they don't know the process, and they get intimidated into doing nothing, which again never helps them. But instead of that, focus on what you do know. Focus on what you do have available. Focus on what you can do. Take action when and where you can, and then get the help that you need to do what you can't do. All right. So I hope that again was very helpful. If you like the video, please share with a friend. Like the video, subscribe to the channel. We are live every Wednesday at 1:30 p.m. Eastern Standard Time. So with that, we will see you again next Wednesday, March 22nd at 1:30 p.m. And until then, take care.